Industrial wastewater disposal faces new legal challenge in Oregon. A newly filed federal lawsuit in Oregon is drawing attention to a compliance risk many organizations treat as operational: the legal exposure that can arise when wastewater management is routed through third-party systems with known violations. In Pearson et al. V. Portland General Electric Company and Columbia River Processing, LLC, residents in Morrow and Umatilla counties allege that nitrate contamination in groundwater and public water systems is being exacerbated by how two industrial operators manage nitrate-heavy wastewater through the Port of Morrow's Industrial Wastewater Treatment and Land Application System. Filed December 5, 2025, in the U.S. District Court for the District of Oregon, Pendleton Division, the complaint seeks class certification for residents relying on private wells and public water systems within areas associated with the Lower Umatilla Basin Groundwater Management Area, LUBGWMA. Plaintiffs assert a federal citizen suit claim under the Resource Conservation and Recovery Act, RCRA, alongside Oregon law claims including negligence, trespass, and private nuisance. Requested remedies include injunctive relief and a medical monitoring program. Allegations center on wastewater routing and permit compliance. According to the complaint, Portland General Electric, PGE, and Columbia River Processing, LLC, are alleged to generate hundreds of millions of gallons of nitrate-containing wastewater annually and to send that wastewater to the Port of Morrow's system, despite alleged knowledge that the port has repeatedly violated its land application permit. Plaintiffs allege the port has committed more than 2,000 permit violations since 2015, and that wastewater is land applied without adequate nitrate removal, allowing nitrates to migrate into groundwater and move down gradient toward residential and public drinking water wells. Data points driving the claims. The complaint ties these allegations to regulatory thresholds and state testing data. The EPA's federal maximum contaminant level for nitrate in drinking water is 10 milligrams per liter, while Oregon designates groundwater management areas at 7 milligrams per liter. The complaint alleges samples in the LUBGWMA have exceeded 40 milligrams per liter. Plaintiffs cite Oregon Health Authority data showing that, as of October 31, 2025, 2,069 residential wells had been tested in the LUBGMA. Of those tested, 24% in Umatilla County and 44% in Morrow County exceeded 10 milligrams. The filing states at least 634 wells were above 10 milligrams per liter, including 226 above 25 milligrams per liter. The complaint alleges the state has installed filtration systems at approximately 275 homes and is providing bottled water to 318 households in Morrow County and 288 in Umatilla County. Individual examples cited in the filing include a private well allegedly testing at 46.8 milligrams per liter, with post-treatment water still testing at 16.4 milligrams, and another private well allegedly testing at 15 milligrams per liter. Why this matters for facilities and compliance teams. The strategic significance of the lawsuit extends beyond nitrate chemistry. The case raises a governance question increasingly relevant for large facilities and industrial operators. To what extent does continued reliance on a third-party wastewater system with a documented compliance history create direct enterprise liability? The remedies sought highlight the stakes. Plaintiffs estimate that connecting affected households to public water systems or drilling deeper wells could average $40,000 per household, with ongoing public water costs estimated at $1,000 per year, figures presented as part of the requested mitigation framework. What to watch? The allegations have not been adjudicated, but the lawsuit underscores how water quality, wastewater partnerships, and permit compliance are converging into a visible litigation risk, particularly in regions where industrial growth intersects with groundwater dependence. For EHS, facilities, and compliance leaders, the case serves as a reminder that outsourced environmental functions do not eliminate accountability, and that vendor compliance histories are increasingly central to risk exposure. You've been listening to Sustainability Soundbites by Environment and Energy Leader. For partnership opportunities, please reach out to our team.